All right, everybody, we are here. We've made it to a verdict. So the jury's been out for like a day and a half and was like, yo, we don't want to wait no longer. Wow. So we got a verdict in the trial. And I don't know where we go from here, but it's up and running. They said the verdict should be announced by 4:30. I think they got to get everybody back. They got to get Chauvin back. They got to get the lawyers back. They got everybody back. So 4:30, we will be here live, reacting to it. They are going to read a verdict. So get ready, get set. Predictions. Oof. Jury comes back within a couple of hours, because they couldn't have been deliberating for longer than maybe 5-6 hours. Early when the jury gets back early, that usually means guilty. But that didn't happen with OJ. Remember, let's not forget OJ. OJ was not guilty. They came back quick too. So, is it guilty? I don't know. Now, just so we're clear, again, I could be wrong. I've been on a good streak though. I've been wrong. 10 hours. They said 10 hours. 10 hours. I mean, oof, yeah. So I'm going to say it. I've been saying guilty on murder 2, murder 3. I wasn't too sure, and man 2. So I've been saying if they come back early, it's guilty. If they come back late, it's not guilty. So we know this is not a hung jury too. So we got a decision going down. So this jury is not hung. So I thought 50-50 hung. This jury's not hung. They've got a verdict. So we are going to see. Nate the lawyer. In Ron Paul meme, it's happening. Oh yeah, it's happening. Let me get that super chat, $5 from I6. It's fast verdict, good. It all depends. If I'm with a client and we go out and they say the jury's back within an hour, right? I'm like, it's either you got a problem, brother. we better hope it was clear, because if they're back in an hour, usually that's not good for the defendant. Let me turn on some lights here. Give me a second, but yeah, we are fast verdict usually means guilty, but you could throw all that out the window. OJ's jury came back fast and it was not guilty on all counts. So we know it's not hung because they got a verdict. Guilty. If we had a hung jury, they would still be delivering. Of course, yeah. Hung means it would still be out. So yeah. So hey, what's going on? What's on, Kevin? So yeah. So I don't know how people feel. Let me pass this link out to some people. I'm gonna see if I can get Hold on, give me a second, guys. I'm gonna throw this link out to some of my legal friends here. First, let me go to. I see you in the chat, Kurt. So I'm going to give this to you. So there seems to be there's been a lot of people in the chat who believes there was reasonable doubt. Do people believe this is not guilty? I don't know. It's always this thing is always exciting. All right, so let me start passing out this link to people who may want to join us. The verdict, here we go. In civil, we got 1, 2. Let me pass it to my man who you guys met yesterday. With Logic, he's in there too. Let me pass one to my boy Nick, even though Nick's usually busy about this time. I'll pass one to him if he wants to watch the verdict. And who else? Oh, Legal Bites. I got to get my girl Legal Bites in here. And those are the people who I think would have them. The verdict is. So, yes, so the verdict is in. Let me close this screen. So I sent it to everybody. Let me look at some of your questions. All right. Good to hear, Nate. Oh, let me see. Let me go back up, make sure I didn't miss anything. All right, so I got this one. Fast verdict, good or bad. For the defendant, it's bad. For people, but again, that's usual because OJ. Whenever somebody says about a fast verdict being good, always hit them with OJ. OJ was very fast. They came back in like minutes, so it was over. Here's another one. Good to hear you have made a prediction. Yeah, I've made a prediction. Have you made a prediction? Yeah, my prediction was guilty second degree, but my prediction was 4. Guilty second degree, third degree, I wasn't sure. Manslaughter, I thought was a gimme. So I thought guilty on some of the counts. Oh, they're putting up this sign. Day 28, Minnesota v. Chauvin, day 16 of the trial. All right. So that's where I'm at. I'm thinking, but again, that's just based on me. 4:30. That's when we're gonna have the verdict. This is exciting stuff, people. I will get my riot gear. Isaac, for the supermarket tonight. They keep your verdict average up. I believe you're 12-0 over Barnes. Yeah. Me and Barnes have been battling it out, but yeah, Barnes hasn't gotten any of these stuff, right? Supreme Court, the whole nine. I've been killing them. But to be honest with you, Barnes can get this one right because Barnes is a hell of a trial attorney. So, if generally, and just to be fair, if Barnes says A and I say B based on the law, just to be fair, believe Barnes. Why? Because Barnes just has the knowledge and experience. Barnes been doing this for 40 years. So generally, I would say believe Barnes. But there's certain things that Barnes just doesn't know because he doesn't do criminal. He hasn't done criminal defense in state courts, and I don't think he's done. Well, I don't think he's done. He was a prosecutor. And he hasn't done criminal defense all that much. No, because he just did the last case. Because there's certain things like he gets so confused about the merger doctrine. He's got confused about. He's getting confused about intent in this case. I don't know. But this is not about Barnes. Barnes, I love Barnes. Barnes is cool. So, but yeah, I'm hoping if I can get this next one, I'll be 13-0 against Barnes. So we'll see. Barnes is going to hate me for that. Thank you for helping me understand everything about this. Oh, thank you so much. It's crazy. This has been a crazy case. And I want to thank you guys for watching and experiencing with me because we've all gone through it together. This is like possibly a split verdict, such as a quick turnaround. It could be, but you're looking for what? It could all be not guilty. Nobody knows what it is, but they know. Thank you again for covering it pretty reliably. I appreciate that. Thank you for coming and checking this stuff out. Oh, the first lawyer to join us on civil law. What's going on?
How are you doing?
I'm all right. We're excited for verdicts here, man. We have verdicts. This is easy.
Well, excited. I don't know if it's exactly the right word. Anticipation for sure.
Well, is it likely possible that there will be a split verdict with such a quick turnaround? Generally, quick turnarounds. What does that mean, Kurt? When you got a quick turnaround, what does that generally mean?
It usually means guilty,
except for
O.J. Simpson. Yeah.
Except for OJ. So this doesn't look good for Chauvin because but who knows? If it comes out all not guilty, I'll be shocked. If it all comes out all guilty, I'll be like, all right, it doesn't buck the trend. So
yeah.
This is crazy. Let me get some more of these super chats. It's coming in fast and furious. So thank you so much. Thank you so much for the super chat. What do you think about the issues with the appellate? I think there are a hell of a lot of appellate issues. What do you think, Kurt? I think there are a whole bunch of appellate issues here.
I saw, in my view, I don't really see anything that's likely to succeed at the end of the day.
Okay.
In my opinion, I mean, there's issues, but none of them rise to my mind that I've seen. But to be fair, I haven't seen every issue, so maybe there's some issues I'm not aware of. But the ones I've seen are not there for me.
Well, all right. So everyone understands when we talk about appellate issues, even if you do have an appellate issue, it has to be enough to overturn the result, right? Even if the judge make a mistake or prosecutors make a mistake, if it's not enough to overturn the result, then it's not really an appellate issue. So some of the appellate issues that have come up is cumulative, right? Is the fact that they had so many people testify that this was not right, that this was not this. The cumulative aspect, that could be an appellate issue. You use too many, you have to do it again. Then the second one is prosecutorial misconduct. When the prosecutor closed, you can't say the defendant's defense is laughable, it's clownish, it's things of that nature, which it's a story. You have to, there's like a level of candor that you have to have that could lead to prosecutorial misconduct that can overturn the result. And then you have some evidentiary issues that may arise. But I think, like Kirk, I don't think there's enough to overturn a verdict, but I think there's enough for an appeal. What do you think, Kirk?
Yeah, with respect to the closing argument, with respect to the belittling of the defense, although obviously there's some evidence to that effect, in my opinion, it was not sufficient to raise a legal issue. It was not of the kind of character of cases that I've personally seen or personally reviewed, or cases that have come up in my channel, where the prosecutor has gone so far beyond the realm that it's led to issues. The prosecutor was definitely, dancing more than, there was something there. So it'd be ridiculous to say there's nothing there. But is it enough to be sufficiently prejudicial to overturn the verdict? Not in my opinion. With
Agreed.
respect to the cumulative issues, I agree actually that it is overly cumulative, in my opinion. That being said, however,
I agree with you.
So let me put it this way: this is interesting because how things go. If I were the trial judge, I would have not allowed as much stuff as happened. If I'm the appellate judge on review, though, am I going to overturn the verdict for that reason? No, because I don't think that, although they were cumulative, and it's a discretion call within the discretion of the judge, so it becomes an abuse of discretion standard.
Yeah.
And is it so much an abuse of discretion that it pleads to some sort of fundamental unfairness? Again, not in my opinion, because of how high that standard is usually applied. So I think the trial judge erred. I just don't think it's legally reversible error.
I tend to agree. And that makes sense. It makes a lot of sense. Here's another one. Judge thought mistrial is possible after Waters' nonsense. What do you think? I think you're gonna have to prove that those jurors took that into account. Maybe polling the jury or something like that. Even though she said it, the fact that she said it doesn't allow you to just claim that it influenced the jury. Especially if the jury, how do we even know they heard it? You know what I'm saying?
You're never going to be able to get that evidence. You'll never get it because it's piercing the veil of the jury.
Yeah.
Which is a major no-no. They will never ask the jury ever in any formal context about this, and it will never be admissible even if they told them about it otherwise, because the secrecy and sanctity of the jury is even if they went on TV and told the press about it, they still wouldn't allow it in a courtroom. Because we treat the jury secrecy very, very paramount. So short of the jury saying we're going to convict because of race or because of sex, because of that kind of fundamental bias, and those are the only two examples I think the U.S. Supreme Court ever reviewed, or because of gender identity, I think might have also been one.
Yeah.
But short of those fundamental biases because they're one race, because they're one sex, because they're gay or not, we're going to come to this conclusion. But short of that no, or short of the jury bringing a Bible into the deliberation room or something like that. So short of something like that, I don't see anything that's going to allow you to even pierce the veil to be able to even ask the question.
Yeah, because Kurt is right. What the jury, how they come to their decision, unless you can prove they got paid or something like that, it's very hard to pierce the veil of the jury. He's right. But again, these are things that are being thrown out there. All right. Hey, this is another question. Hey, what's up with the comments made by Maxine Waters? Was it just a bunch of media balooey, or were her comments more problematic?
Person.
Well, let's just be clear. Myself, Kurt, Viva, or every attorney who have sat here and talked about this case, we all believe that those comments were inappropriate. They were unnecessary, and they did more harm than good, right? Because if it almost taints the conviction, right? She didn't need to say it, and that's why I wouldn't vote for Maxine Waters, because I think she and you do, and she has given this defendant some avenue of appeal, even though you don't know if it's slight but she has given this defendant, hey, I couldn't get a fair trial, when she's screaming, if I get a fair trial, essentially threatening the jury. So I think it's a lot of media hoopla, but I think the judge did address it in a fair way, and we'll see what happens. Dean says guilty, but overturned on appeal, thanks to Weezy Jefferson, aka Maxine Waters. Well, we'll see. Oh, hold on, this thing is just moving so fast.
Yeah, the short way to figure out if any of these things will be reversible is if this hadn't have happened, would the jury come out? And remember, on appeal, it's the presumption of innocence is backwards. So he's innocent until proven guilty. If the verdict is guilty, now that is now the decision. So now it's guilty until proven otherwise, basically, because now all the evidence is going to be interpreted. Basically, the short way to think about it is all evidence is interpreted in favor of the current reality. So the current reality as of this moment is that Chauvin is innocent.
Yes.
So all the evidence is interpreted in that light, because that's in favor of the current reality. If the jury comes back guilty, all the evidence is going to be interpreted in favor of that verdict, in favor of that new reality, that he is guilty. So the question isn't now, beyond a reasonable doubt anymore. The question is now for the Court of Appeals, if you remove that from the equation, could a reasonable jury still come to the conclusion they did? So the answer would be like, if Maxine Waters had not done this, could the jury still come back guilty? And I think the answer is yes. So I don't think it gets to be overturnable.
Yeah, I agree with you. I gotta get through these because these things are coming in faster. Barnes has a significant disrespect for bad laws and bad precedent. Let me turn this off. Mute the screen audio. And bad laws and bad precedent, and speaks with an eye on reversing them. Once you understand that, anything Barnes says wrong makes sense. That's true, but the thing is that when you're trying to do legal analysis, there's a difference between legal analysis and legal commentary, right? Legal analysis is taking the facts you have, putting them into that box of the law and seeing what comes out. And if I'm wrong on the law, then you're going to be wrong on the outcome. So if I'm wrong on what intent is, and I'm telling you guys what intent is, and he's wrong, then you guys are going to come to the wrong outcome based on his misunderstanding of the law. And like, for instance, here, he didn't understand that assault can lead to felony murder, right? He was wrong on the law. And most people were like, oh, there's no felony murder because assault can't be an line felony. Then when you find the case and say, no, you're wrong, here it is, then people have to understand, okay, that's an issue. Then when he says you have to prove specific intent for assault, you don't have to prove specific intent for assault. That was wrong. So it's kind of going through all that and trying to, I want to say, deprogram people from his misunderstanding of the law so you can have the right understanding. So whatever the conclusion is, you'll understand why the conclusion is based on the law and not just someone who believes that the law is wrong. If you believe it's wrong, fine. But you should at least tell people what the law is now so they can make a determination based on what the current state of the law is, not what you want it to be. Here is, I appreciate your work. Have a beer on me. I will definitely do that. You saw me yesterday having a beer. Me and Kurt used to drink on stream, but people started telling us we were alcoholics in training, right? I'm like, what do you mean alcoholics in training? What's wrong with you?
What do you mean in training? I passed the bar exam.
I got that one. Nate, thank you so much for covering this. I love your view and how fair you are. Keep up the awesome work. Thank you so much. I try. But the thing is that with these things, it's funny because that's what me and Kurt do. Me and Kurt are legal communicators. We try to communicate the law so regular, everyday people can understand it. Because if you don't, it's one of the most important things that we have in our system of government. And it's so funny because most people have no idea how it really works. But everyone is so influenced. And everyone's lives are so influenced by what actually happens in the courtroom. So it's an interesting thing to be a legal communicator. But I just hope that whenever you watch a stream of mine, that you leave that stream understanding more about the law and the legal system than you did coming in. Here's the other one. If Chauvin is convicted of any charge, will his friends plead the fifth? Who supposedly was his dealer? He's already done it. He's pleading the fifth. Yeah. Also be charged with the same crime. Yes, which is crazy, right? All right.
Yeah, exactly. They can all be guilty.
So this is it, right? So the theory of the prosecution's case against the dealer is that the dealer gave him drugs, and his name died, with drugs in the system, the drugs that the dealer gave. So under third degree felony murder, if I give you drugs and then eventually you overdose or die, right? I get charged with felony murder. I presented you. So the dealer, it's possible for him to be charged with felony murder for giving Floyd drugs. And then Floyd, it's insane. It's like this felony murder rule.
It's just third degree murder. I don't know.
Yeah, it's third degree.
I don't know if you can do felony murder for that or not.
No, they have third degree.
That's third degree. Specifically enumerated in third degree.
Yes. So it can't be second degree murder. It's third degree murder. Yeah. Because that's what if you watched earlier his pleading the fifth. That was the one thing his lawyer was like, no, he can get charged with third degree felony murder because he had drugs in the system. If you're saying the drugs were for him, that's it. So so the dealer, so it's possible for the dealer to be charged with felony murder for the same killing of George Floyd. I know it's insane, but that's why the dealer is taking the fifth. He can be charged with felony murder. Insane. I know. Insane. Don't hate me. Thank you for the thank you for the $5.
Don't shoot the messenger.
Oh yeah. But that's the reality. Isn't that insane? No, for one death, you could have two people charged with felony murder, one for the assault and one for the drug sale. So what the hell caused? And that's why I think they didn't go after the drug dealer at all. They haven't charged him. They said nothing, right? They just went after Chauvin because they said we can get Chauvin. Then the drug dealer, we got him on other stuff, right? We got him for dealing drugs. We don't have to get him for felony murder. So it's an interesting aspect of it, right? Let me see. I'm trying to. I know the chat's coming in fast, so I'll see if I can get what's going on. So at the end of the day, what was your prediction for this case?
Well, I don't like to predict a jury, but I did as to my personal conclusions, given the law and how it reads, I found guilty for murder in the second degree, not guilty for murder in the third degree, and guilty for manslaughter in the second. I did a stream last night where I tried to explain the exact legal posture in Minnesota, which bears some emphasis because Minnesota has some weird aspects here, and try to look at the evidence. The defense, it seemed to me, had two bases for saying not guilty, for example, for murder in the second, either justification or causation.
Yes.
So causation would be that Chauvin is not a substantial contributing factor. And as Nate points out, because other things are substantial factors does not mean inherently by itself that Chauvin isn't also a substantial factor. More than one thing can be a substantial factor. So you could believe, consistent with the law, that Floyd died because of drugs, because of high blood pressure, because of his heart condition, because of insert X. And if you also believe that Chauvin was a substantial cause, then Chauvin is guilty and other people might also be guilty at the same time. So I was like, okay, so can you say that Chauvin is not a substantial contributing factor? I think the answer to that question has to be no. So I don't think causation works. As to justification, he was justified in the first instance, but the justification at some point lapsed. For me, it lapsed at least at the point where they say there's no pulse. And he had the knee on and he had his knee on his back or neck for another 3 minutes, which, you know, if Floyd wasn't dead at that point, it would be felony assault. If he was dead at that point, it would still be attempted felony assault, which is just as good, because you don't have to be alive for it to be an attempted assault, because attempt goes to your internal intent, not to the underlying reality.
Yeah.
So, you know, I didn't think that justification worked. So because I think causation wasn't a valid defense, because I thought justification wasn't a valid defense, I thought murder in the second degree, and we could go from there, but that's enough for now.
Well, this super chat I want to bring up. Jake, you just do not understand American law. That I can say you can go take a bar exam, you know, go do some research, just go look at it, right? And I'm going to give you some things you need to Google. You need to Google the difference between specific intent and general intent. And when you're talking about general intent, right, for an assault, general intent means, and here's an example for you, Jake. If I was to slap somebody on the street, right, maybe even a light slap, right, and I intended to slap them, and I happen to slap them, and next thing I know, they fall, hit their head, and go into a coma, right? My intent was not to harm them, not all that harm that happened to them. That wasn't my intent. My intent was just to hit them slightly, but I intended to hit them. So the law says, well, since you intended to hit, all the consequences that happen because of that hit, you're now responsible for legally, criminally responsible for. That's what's called a general intent crime. I don't have to intend the harm. I just have to intend the act. Where you're talking about a specific intent crime, that's different. There, I have to intend the harm for like something like a simple theft, where somebody has my same phone, and I grab the phone. I intend, like, we have two phones right there, right? One is mine and one is someone else's. I intend to grab that phone and take it, right? Now I have that. I've intended to grab the phone. I've taken it, but I didn't intend to steal it. I didn't intend to deprive the person of their property. So the specific intent says I have to intend the harm. I don't have to just intend the act. So Jake, look it up. Don't trust me. Don't trust me. Go look it up and try to understand it before you make statements like this. Because again, this is American law, and American law. And I see you got a Texas flag there. Everything is bigger in Texas. Look it up and you'll see exactly what I'm talking about.
I got a Texas flag here.
That's true. But Jake thinks Jake thinks I'm wrong. So Jake, go check it out. Trust me, Jake. We're lawyers. I wouldn't steer you wrong. Part-time 3L, thanks for the insight. They will probably use murder to pressure a plea on drug charges. Thoughts, Chris? Number one, when you get that law degree, come on up here and join us, baby, because you know we're always happy to have another. And good luck with the 3L. Let me see. They would probably use the murder to pressure the plea for the drug charges. Thoughts? Yes, of course. I think they definitely would. What do you think about that?
At this point, though, because the thing is, when you're usually doing this kind of pressure scenario, you're usually doing it in a fog, a veil of fog, because it's like there's a lot of unknowns. So normally, when you're trying this game of pressuring the defendants, like, we could charge you with this, but plead to this, but so much of the future is unknown. So it's like a risk assessment. But here, the prosecution's case is kind of completely open and exposed. So I don't know if that strategy will work. So I don't know. I mean, they can try to leverage, but the leverage position is not as good because the defendant has way more information here than they would in a typical case.
Oh,
so
yeah.
I don't know if it would. I don't know if it would work.
Here's the next one. Were there any black male American jurors veterans? In my opinion, has a chance then. I don't know. I know there were a couple of black jurors. I'm not sure there. I know there was one black male, but I'm not sure the full makeup of the jury. Maybe, I don't know. And I wouldn't assume their verdict, based on, their race and veteran status. I just don't know. It just, I wouldn't assume. But again, everybody has their opinion. Sorry, Matthew. I just don't. I don't know how to answer that question. Lucius says the only thing that makes sense is manslaughter. I agree. If this wasn't Minnesota, I would agree. right. I'm talking about. Let's be honest, right? Let's just be honest. If this wasn't Minnesota, I would agree.
Yeah,
you're right. But we're in Minnesota.
Yeah.
So I think murder in the second degree also makes sense. But you're right, though.
Yeah.
Manslaughter, I think, is a home run. Murder in the second degree, I think, is just a unique folly for that. The overdose makes more sense given Floyd fast. Again, reasonable doubt was paramount. But listen, even if he was in the throes of a drug overdose, it's was Chauvin a substantial factor? People, you just can't kill people who are having drug overdose. Like, say if he shot him while he's having a drug overdose, you can't say, well, he was dying of a drug overdose, so I just, it just doesn't work that way. But I do understand, when you have a lot of these causes, the one thing that I think people can't overstate is that you had so many doctors for the people say that this was not a drug overdose, and even the defense's medical examiner, he didn't say Floyd died of a drug overdose. What did he say? He said it's inconclusive. So people who are saying he died of a drug overdose, you have none of the witnesses, none of the expert witnesses, even on the defense side, said that. So I'm sorry if that's just, I don't want to call it fake news, but it ain't the facts in this case. You're talking about another case.
Yeah, the inconclusive thing is slightly odd because that's a medical determination. As like, we can't determine the cause of death because there's multiple different things, and we can't determine which of them it is. So, but from a legal standpoint, the prosecution still is good. Because what that would be basically saying in this case is we can't tell if it's a drug overdose or if it's because of what Chauvin did. So we can't tell homicide versus accident. We can't split that difference medically to determine which is the cause of death. But legally, it's like, because if I can believe both at the same time, that's what's great about law. It's like I can simultaneously believe homicide and accident because murder is a legal determination. Homicide is a medical determination. So I can believe homicide and believe accident and believe murder all at the same time because of how this works in this reality. So fun times.
Yeah, facts. All right, so just so we can go over the quick charges, in Minnesota law again. All right, the first charge we have is second-degree murder. Second-degree murder is felony murder. Felony murder, what you need for felony murder is you need to have an underlying felony, and in commission of that underlying felony, a death occurs. So in this case, they're saying the underlying felony is assault, which is, again, unique in Minnesota. Most states don't let you do this, but in Minnesota they do. So the underlying felony is assault in the third degree. If the state proves assault in the third degree and that this death resulted in the commission of that crime, then you have felony murder, which can get you up to 40 years. The second is murder in the third degree, which is the depraved indifference. That's the depraved mind. That's
depraved heart. Yeah,
depraved heart. The simplest way that you can really explain that's your Russian roulette, where you put one bullet into a revolver, spin it, and put it to somebody's head and pull the trigger. If you kill them, that's really your third degree depraved heart. And then they have second degree manslaughter, which is your culpable negligence. That's where you've done something where you took a conscious risk to do something that was inherent, that was dangerous, and that it resulted in someone's death. So that's why they'll say the conscious disregard, to take an unjustifiable risk. They're saying by holding him in this position for so long, it was an unjustifiable risk because it could hurt somebody and then it caused his death. So those are the three charges that we're looking at. Now, most people, I think most everyone understands that the second-degree manslaughter is probably a home run. It's really between the third-degree murder and the second-degree murder that I think a lot of people are having issues with. Let me get some of these super chats. We're what 4 minutes away from verdict. If I don't get to all, if you,
I'll be 50 minutes late.
Yeah, but I'm getting it. So if you also, for people who send, we're going to try to get to them all. But if you send super chats and we don't get to them, we may just pop them up on the screen. Don't be upset with us. And if you can't, take your super chat not being read and possibly not being read, don't send it. We're going to try to read them all. I'm going to make an effort to do it. But if I miss something, don't kill me. I'll try to get it back. I think people need to understand that the mob wants first degree. Yes, but we only got second degree and will rage at any verdict. Facts. Don't try to think for the mob. It's a wild animal. Yeah, I tend to agree. I think there's going to be a lot of emotion to go with this. Can you give a little more clarity on what the Blakely notice will do to the point of the verdict will be issued? All right. So for my research for this notice, it is in most states, like in my state, if you have a crime, let's say if you have robbery, and you want to make it to like you have assault and you want to make it an aggravated assault, there's a statute that already has those aggravating factors in it. So the jury, in finding like aggravated assault, already has to find those statutes, those things in the statute. So as the aggravated assault, maybe assault with a gun. So the jury would have to find that you did it with a gun and you have aggravated assault versus just a regular assault. In Minnesota, it seems like that they separated it in a way where you find the person guilty of assault, and then you have like another step where you can find somebody guilty of the aggravated assault, like that second piece of it. From my understanding, is that what do you think about? Is that Blakely?
Yeah, that's my understanding too. So you're looking for these aggravating factors, and they have to be determined by a jury. So it's essentially
beyond a reasonable doubt.
Yes, beyond a reasonable doubt. It's a sentencing enhancement. Yeah. So it's somewhat equivalent in federal law, where you have the crime and then you have like how bad this crime is, and it's multiple different tiers. So you're basically trying to move from it is the same crime, but it's different levels of bad of the same crime. And so it's like moving one tier to another. And in order to do that, you need to find these aggravating factors. And so you go to a jury and say, okay, do you find them beyond a reasonable doubt? In the absence of that, the judge can do it. So yeah, the judge will be doing that. So, okay.
And Chauvin's waived his right, because you have a right for the jury to find you beyond a reasonable doubt. I love how you guys, I love how you provide the facts on the law. I may not like the law, but we have to follow the law. Not following the law is not an option. Amen to that, brother. Amen to that. Thank you both for your time, dedication, and education on the topic over the last few weeks. Much appreciated. And please go check out my boy Uncivil Law on his channel, Uncivil Law. He does great content. You'll get a lot of appellate reviews. And if you want to learn the minutiae of the law, the fine details, go to his channel, because he goes through it and a lot better than I can. I give you the 30,000 foot overview. He goes through you line by line, word by word. So that's what Uncivil Law does, and that's why I think we make a great team. Do you think the jury will should have been sequestered to prevent appeals grounds? What do you think? Because if they were sequestered, Maxine Waters doesn't matter.
I don't know how much difference it would have made. And the reason I say that is because everything that is putting pressure on the jury now, in terms of the violent, because of the protests outside, even in terms of Maxine Waters' comments, they are not different in kind to what there was before. You could argue, I suppose, they're different in degree, but even that's a little bit dubious, because you think about the jury's position before they were impaneled, and what was the state of the world at that time, and what is the state of the world now in terms of the external pressure being put on the jury. It's like, at least to my mind, the external pressure that was being put on the jury the day they were impaneled is not different in kind to the external pressure that's being put on them now. It has maybe a slightly different degree. Maybe you think Maxine Waters' comments are substantially different. Personally, I don't know how much substantially different they are to other comments from other people in the time. So I'm not sure how much difference it makes one way or another. So I don't think the sequestering will be enough to overturn the verdict, because the question would be, again, because you have to, if there's a conviction, right? In the same way we say proof beyond a reasonable doubt, he's presumed innocent at this stage. If he's convicted and guilty, we then have to interpret all the facts in light of that new reality of guilt. So the question would be, if the jury was sequestered, would it have made a difference at that point? And it's like, it's a little bit hard to reach that conclusion, in my opinion, because the pressures are comparable, I think.
Yes. I agree. It's good. It's a very good point. Joe Delez says, it's like how if you killed someone dying of cancer, you can't say, well, he was going to die of cancer anyways, and expect to be let off the hook. Perfect, great analogy. Yes, it's exactly the same thing. But again, it depends on what the jury. If the jury feels that he was going that Chauvin wasn't he was just, if he just thinks that if the jury just thinks that Chauvin was just a contributing factor and not a substantial factor, then he's off the hook. So, but we got to see. We got to see. Does a threat against the expert witness mean anything? They left a pig head and spread blood over his house. I don't know.
That is a fair point. That is arguably a difference in kind to the threats before. So, but they were already sequestered at that point. You can't get to there. So because the jury doesn't know about that.
Yeah, I don't know. Threats against the expert witness is one thing, but I don't know if it's going to affect, if it didn't affect his testimony. I'm thinking they were talking about, but yeah, if it just affected that, then I don't think you got it. Yeah. Let me see. I'm going to try to get some other comments, but I really want to get to these super chats because I feel bad when I don't get to the super chats. All right, hold on.
They love you, Nate.
No. Well, I feel if you sit one in, I want to try to get to it, and I know this stuff is coming. All right, so a couple of them just left. Going to be argued that assault must have some intent, i.e., a person has a heart attack in two scenarios: one slap victim, and the other one is shaking his hand. Shaking his hand is not criminal, right? Yeah. So shaking someone's hand is not against the law. Slapping them is. If Floyd has a blood oxide at 98%, how do we reconcile the people's assertion that Chauvin's actions caused him to die of asphyxia? Because they gave him oxygen in the ambulance, and they gave him oxygen in the ER. So that's why his blood saturation level. And the inverse relationship between carbon monoxide and oxygen is that they bind to the same thing. So if you have more oxygen, then you'd have an inverse relationship to carbon monoxide. So that's where you get it. Here we go. Nate and Uncivil Law. Having seen the case unraveled, what do you guys think of the prosecution defense could have done better? I'll let you take that one.
Things. We could talk about that for a long time. Maybe we should move on and talk about it later.
Yeah, we'll definitely get to that especially after the verdict. We'll definitely answer that question. Do you think the jury's coming back this quickly leans toward a guilty verdict? Generally, that's what it means. But OJ, they came back early with OJ. They came back, I think, the same day or something like that with OJ. So it is what it is. I hope I speak for all of your subs. We are the small portion of Americans that love nuance. You break it down so well. Thanks. Cheers, Heineken. Yes, the Dutch beer. Because people were getting on me because I called it a German beer. Like,
it's not.
You. It's the same continent, but the wrong country. All right. Yes. They're actually next door neighbors too. So 6 months ago, you called Ron DeSantis incompetent. Now looking back, has it changed your mind? I still think DeSantis was incompetent for a couple of things, but I think Cuomo's incompetent too. What politician don't I think is incompetent, right? I think the right and versus the left, I think they're all incompetent. So yes, Ron DeSantis, he's just as bad as the rest of them. Just as bad. I think Biden's incompetent, right? So, if you want me to single Ron DeSantis out as not being incompetent, then you got to, that's a high bar. That's a high bar. But I don't think he's as bad as I don't think he's any worse than the rest of them. If that's what you're getting at, no, he's not as bad. He's just as bad as the rest of them. Actually, I think Cuomo's worse, to be honest with you. I would rather have Ron DeSantis than Cuomo. So, if that's saying anything, fentanyl and drug cocktails in his system induce symptoms. Acquittal on odds that the drugs killed them. Ooh, I don't know. The drugs killing him. I don't think that's because you know what medical evidence did you have to agree with that statement, right? All the medical evidence is against that. I don't see how you get there. I just don't see how you get there. This thing jumps so horribly. I hate this. Yeah, but I don't see how you get. I don't see how you get there. Here we go. Cancer is more passive. Would it be more like having a heart attack while having sex? No, let's be like more like having a heart attack while in the commission of a bank robbery. If you go to a bank robbery, somebody has a heart attack, right? There's no, though, you've caused stress in them and they've had a heart attack, right? You didn't shoot them, you didn't kill them. In every place you go, that's felony murder. Am I right, Kurt?
You are correct, sir.
Yeah, so that's felony murder. The person, and you're talking about somebody who already had a pre-existing condition, right? That person's heart is bad, and most people who are healthy would survive that. So, so that's what we're looking at. That's felony murder. Nate, what are you hitting? This is what is this? This is, I think it's strawberry. It's a strawberry something other. A friend of mine got. Obviously it's just a vape. But it's actually pretty good. It's actually pretty good. Makes me. It gives a nice taste, but I don't know. I think I'm gonna stop because they always say the lung thing is getting bad. Afternoon, gents. John O'Brien, the lawyer in disguise. I agree with uncivil on the murder in second degree and man 2. The speed of return, relatively lack of questions makes me think man 2. If anything, any guilty verdict, the appeal writes itself. Amen to that, brother. You are hitting on all cylinders. I definitely agree with that. The appeal writes itself, but I don't think the appeal may be successful. But we'll see. Because the appeal is successful, we get to do it again. Go ahead.
I was just going to say the murder on the 3rd does have some interesting legal issues because there's this one Minnesota Supreme Court case that I can't remember the name of that seems to counsel against murder in the 3rd degree under this factual scenario. So if we want to pull that up later, we can. But there's one specific case that makes me think murder in the 3rd is not legally tenable. But we can discuss it later.
Hold on, this stream is starting to buffer a little bit.
Maybe everyone in the world's trying to watch it, right?
Yeah. So to make sure we
If it cuts to Black Soprano style, I'm going to be very unhappy.
I'm just making sure that we get the best feed here. Uh-oh.
What'd you do, Nate?
Nothing. I'm just checking different feeds, making sure things are working, making sure things are right. So I got 2 feeds up just in case. There are over a dozen live streams, but I came to this one because I think it's the fairest and most unbiased one available. Oh, thank you so much. We try to be. But it's I appreciate that because we try to really stick close to the law, and that's one thing that me and Uncivil always do. It's funny because you'll see sometimes though our legal conclusions actually counteract our political persuasions, right? Even though politically I'll say I lean more left. If something what was it, the Pennsylvania one, right? The Pennsylvania one where as a lefty I'm supposed to say it was good, but I said it was bad, and so it's, and that's what we're about. We're about the law, and what the law says, because at the end of the day, the law is something that I think if we all had the same facts and we all understood the law, I think we'd have a lot more understanding of why things happen than what we do now, because I think a lot of it's just based on ignorance. Like a lot of people just don't understand. Amy Jo Frazier was beaten and died at Howard High School in Wilmington, Delaware in 2016, avoiding punishment due to her heart condition. Yeah, but again, that is Delaware. We're in Minnesota. Great point though, because I'm assuming Delaware has the merger doctrine for the felony murder. So it's different laws, different states. It's tough to compare. All politicians are inherently incompetent. Welcome to the Libertarian Party. Amen. I'm voting for Ron. Was it Ron Paul? Was it Rand Paul? Yeah, Rand Paul, I think it is. Please tell me your opinion on Mr. Blackwell's prosecutorial misconduct during the closing arguments. I think Blackwell just makes too many silly mistakes, like with the questioning, and it's almost a mistrial. Like this is like the second time we've thrown up mistrial every time he fucking gets up there. I think Blackwell doesn't. I don't know. Maybe he's done this before, and well, of course he's had to do this before. But I'm thinking, even if you do have great points, you have to have a certain candor, especially in a criminal trial like this. So I don't know why he kind of went off the rails like that, but I don't know. What do you think? What do you think about the prosecutorial misconduct at the end?
No, it doesn't do enough for me. As I said,
I don't think it does enough.
It does enough for me.
I don't think he should have done it, but I
don't
but
think
why
he should
take the risk though? It's like the risk.
Yeah.
Why take the risk? It's like stupid. So concentration was 1.28. We'll kill you within a couple of minutes, and 30 minutes. Okay, well, I don't know. For right now, I know they said it would. They actually have the test for his CO concentration level, and they said it was within the normal range. They have the actual
they
test.
did.
So we know that didn't kill him. How does
we know the jury doesn't know that, but we know.
Yeah, we know. Yeah. How does the Southern District of New York get away with indicting almost everyone in the U.S. based on the slimmest connection to NYC, like their border wall indictment? All right, the border. I understand that, but it's kind of like because each of the jurisdictions. Well, let me do it this way: the Southern District. Turn it off, Aubrey. The Southern District of New York is unique because Wall Street and all that stuff happens there. So when you're talking about financial crimes, most of the times it's going to pass through Wall Street in that financial sector. So that's why a lot of times when you talk about these financial crimes, the Southern District of New York jumps right on. Bernie Madoff, for instance, all these big things. And then We Build the Wall, they incorporated and they had these issues and they got donations from New York. So Southern District of New York was all over it. And that's the glamour. That's the glamour spot. So, it's a little easier, especially for the Southern District to get it, especially because of where they're situated in the financial capital. Let me get this. Oh, got John for $5. Right. I tend to be more right leaning and think that Minnesota law is crazy. Facts. We agree with you. And could use some reform. But it is what it is. Yeah. You can't you can't argue the law, right? They've been living there all that time, right?
Yeah, the law is what it will be for today.
Adjusting for internet, this bigger than the OJ verdict. Yes, I think it may be. I think this may be bigger than the OJ verdict. In terms of press and in terms of just the media. All right, this feed is just acting crazy. So I'm gonna turn this feed off. I got another feed. I'm gonna use the Fox feed. Let me use this Fox feed. I'm gonna share. I wonder what's taking so long here.
For the jury, I knew they were going to be late. 4:30, or does it mean 4:30?
That's true. Right. Let's use the Fox feed. Let me turn this one off. Let's see if I can get another feed because it has that stupid logo. And all of a sudden, that stupid logo. But now it's funny. Do you think this is a bigger verdict than OJ, or do you think it's about
the culture is different, but it feels a little bit more like Rodney King than OJ to me.
Yeah.
But even then, I don't know how close it is because the reality is a little bit different than it has been.
Yeah. Sky News. I'm trying to find a good stream. Pioneers done. Boy, everybody's live right now. They are. This is world breaking news here. I would use PBS, but PBS is hard to hear. Star Tribute. Oh, all right, Star Tribute. This is a good one. Sorry guys, I want to just get a Fox. Whenever you got Fox News, they kill you. So let me turn this on. They still haven't gotten in, so let me share that screen. Share audio. Listen to my man type right here. All right, so we should be back on.
Yeah, I'm trying to rebroadcast this on my own stream.
Oh,
so I'm just setting it up.
I'm here you.
I'm tapping.
All right. Where is Viva? Viva may be picking up the kids. Viva picks up his kids about this time. So, but I sent him the link. So hopefully he'll be up here. I sent to a couple other people too. So, but we will see. We will see. All right, $5 super sticker. Thank you. All right,
you get your logo on my channel. You get your branding, so you should be happy there.
Oh, will the judge know the verdict before the jury reports it? I don't know in this state. Generally, in most states, they hand the judge the verdict. The judge reads it to make sure everything's okay, passes it back, and they has the jury announce it. I don't know how the state does it though.
Yeah, I mean, they said they put it in an envelope. So yeah, I don't think anyone knows the verdict at this stage other than the jury, because the verdict envelope is sealed and it will be open. So I don't know exactly how it's done in this state, but yeah, Nate is right. Typically it's opened, reviewed by the judge to make sure it's complete, to make sure it's correct. And then it's usually handed to the clerk to formally announce it. So that's usually how this is done in most states.
Yes. Loved your coverage on this. It's a shame that it's coming at the end, but the journey and the legal knowledge will always stay with us. Thank you. Also, how long until the jury makes the verdict? It should be, hopefully, they said 4:30, right?
Any moment.
We're looking for any minute now. Right?
We are waiting.
Yeah.
Every moment to see what is going on as we stare at the seal, the great state of Minnesota.
To your opinion, do you think he's guilty? I thought he was. Well, again, he can only be guilty under the law of the competent jurisdiction. Under the law in Minnesota, right? I think he's guilty under the law in Minnesota. Man 2, yeah. And I think they've proven him guilty under the second degree felony murder. But again, that's specifically for Minnesota, though. You know what I'm saying? And how I understand Minnesota to be. What were you going to say, Kurt? I'm sorry.
No, I just completely agree. I did a whole thing on my stream yesterday, going through it legally, going through the elements of it. So for me, legally in Minnesota, which I say with emphasis because Minnesota weird, but yeah, guilty murder second, not guilty murder third, guilty on manslaughter second is my best conclusion under the laws of the great state of Minnesota. Yeah.
It seems like YouTube is having some problems too, because now everybody, all these streams are like stopping. We'll see.
Stopping and starting. Maybe lower the resolution if it makes any difference. I don't know, because I don't want to be interrupted when they start actually announcing things.
Oh no, I got 2 of them running just in case. So.
Okay, well, thank you.
It's not.
I don't want to be a grumpy on civil law.
So soon as they start saying something, we're going to be all over it. It doesn't matter. It doesn't matter much if they find him guilty. There is enough for there be appeal. Yeah, there's enough, but having enough for an appeal isn't the same as winning an appeal, right? So appeals are hard. Appeals aren't easy. There's a lot of people looking for an appeal. So, and you have to kind of figure out, is it, when you're looking at appeal, you have to ask the question, is there enough here that would have overturned the verdict, right? Or made it unfair? So that's what you're looking at, right?
Yeah. Oof. Something of fundamental unfairness, which I haven't seen of that kind of thing, or some sort of error that would have changed the result. So absent that thing, would it have come out differently? And it's a hard standard, and I don't see it right now given what I can see.
Yeah, it's going to be tough. It's going to be tough. All right, here we go. We got the Sun feed up finally. I'm going to switch to the Sun's feed. Hold on.
I wonder if Crime Talk is having any better luck.
Usually
their feeds, Crime Talk is usually pretty good on their feed.
Yeah. Hold on. I'm just adding this feed to it.
Crime Talk, he's a pretty interesting guy.
No. There's been a lot of lawyers that I've been following on YouTube. Let me try this one. Hold on. Share audio. Hit that. That's our good old. Oh, that's the other one that we had. The one that's not working. Sorry. I'm having my boomer moments now.
The spinning wheel of reloading somehow has a very what's the right word? A very morose interpretation or something, given what we're talking about right now. Has a very sort of dark comedy to it about the thing. The spinning wheel of justice here.
Yeah, right.
Spin, justice wheel, spin.
Oh my God. Here we go. So thanks for that. The Sun's feed is there. Sun, innocent. Oh, this person says innocent murder 2, or manslaughter, but guilty on felony murder, which is an oxymoron. So hold on. No, well, he can't be innocent of murder 2 or manslaughter, but guilty of it's you got to. All right, murder 2 is felony murder, so you can't be innocent of murder 2 and then guilty of felony murder. That's the oxymoron, right?
Yeah.
So yeah. This should say is innocent of 3rd degree murder or manslaughter, but guilty of felony murder. That's what I think you're trying to say. And yeah, I think it's unfortunate, but in Minnesota, let's just be fair. In Minnesota, it's easier to prove an assault than it is to prove manslaughter, and you got to prove an assault for 2nd degree murder. It's not me; it's the legislature up there. Thanks, guys. It's been fun. I hope you both survived the aftermath. That's true. That's true. Well, you're in Texas, so I don't think you got to have too many problems there.
Well,
right?
I'm in downtown Austin, so I wouldn't, put money on it.
Oh,
I wouldn't put
yeah.
money on it. I'll just stay
Appeal-
inside.
Appeal means wild rioting. But again, we don't. That's assuming he's found guilty, right? People are assuming he's found guilty. We don't know. They could come back and say, hey, he's innocent, right? Or innocent. He's not guilty because we don't do innocence. So
That should go super well.
Yeah, so we don't know. Police are closing the gates to their headquarters. This could be an indication of the verdict. It maybe not guilty.
I think they're just prepping either way.
It could be everybody's reading those tea leaves. Police are closing the gates. This person said this. Maxine Waters is going to jail. It's like, what's going on?
My friend Leadian says he's getting good luck from PBS NewsHour. So,
well, we're good now because we don't have the spinning wheel of death
for the moment.
You see, now we've been here for almost an hour now, and we've got nothing. Come on. I wonder what they're talking about.
Well, they're waiting for the all clear from everything. They're waiting for everyone to show up, and they're waiting for the all clear from whoever is organizing this in terms of the safety side of the National Guard or whoever. It's like, are we prepped and ready to go in case this thing goes south?
Viva!
What did I miss, guys?
Is Viva here? Hey, Viva.
Tell me if my mic is too loud.
You sound great.
No, you're good. You're good. Yeah.
Okay. So I'm behind. I've been in a car for the last like 2.5 hours.
Hold on, let me read the super chat. How can we expect the police to do their jobs moving forward? Was justified to use more force than the prosecution's witnesses? Was clearly with the clear history of ODing. Listen, it's not up to us. It's up to the jury, right? And I'll catch you up with. Let me just do this last one. Ketchup on eggs? Yes or no? Yes. I'm a sick man, but yes.
Ketchup can go on anything, really, except for ice cream.
Well, I don't know about the ice. I might even put it on ice cream. And how do you think this will affect police recruitment, retention? Cops will resign over a guilty charge. I don't believe cops will resign over a guilty charge because you had all of them testifying against the guy. So, I don't think you get that. But now, Viva, what's up, bro? What's going on?
How you guys doing? Hold on, I gotta bring my screen back. So I don't know what you've said. I listened to 5 minutes about 40 minutes ago. But I suspect both of you think that short deliberation conviction is on the horizon.
That's usual.
Yeah, our thing was generally that's what that means, but OJ, because OJ was a short deliberation. So it can, but sometimes it doesn't. You know what I mean?
This was my theory. You're going to hear the dogs barking like crazy.
Take back Justin Bieber, man.
It's funny. You guys get a lot of our good stuff and a lot of our bad stuff. Like you got Steven Crowder, but you also got Justin Bieber. Jim Carrey was good at the beginning, and then he went a little crazy because politics ruins everything. Here's my thought, and I made my prediction, in Twitter. But the charges here were sufficiently complicated that if you were going to get to like around the house conviction on all three, I would have thought the deliberation would take more time to get to a full conviction on all three charges. But we'll see. It's very, very short and very surprising. But you think is it going to be 5 o'clock on the nose, or is there going to be like?
They said 4:30, so I think
4:30.
So I think they just set everything up. My understanding is that they wanted to do this with plenty of daylight left, regardless of the vote.
How does the song "It's 5 o'clock somewhere" now play into this?
The True Legal Dream Team on the stream. Boom,
represent.
Guys, I'm going to be back in 30 seconds because I want to show you something very funny. Hold on.
All right. Here somebody says ketchup on ice cream actually does work. Syrup is better, but things you learn as a child. Well, I haven't been doing ketchup on, but it is what it is. It is what it is. But hey guys, I'm going to say it's interesting because with this verdict, I just don't know I don't know what to expect because I honestly think it can go either way. Let me put Viva up so we can see what he's wearing because I can't see.
Oh no, here I'm wearing it right now. I have discovered nonviolent protest, lawful nonviolent protest. If everybody out there wears these in areas where you're required to wear masks outside, how are they going to know who to ticket?
That's true. It does look like your face is a little ashy though. So
well, yeah, You know, my prediction, by the way, it's only a matter of time before, by regulation, they make face masks intended to look like faces illegal. Guaranteed, because politics ruins everything, and the government pretty much ruins everything. And this is
that's an awesome mask.
Here, check this out. Custies. And I'm gonna put a little video up on Twitter because it's. I saw this guy. He has a channel called Burnt Rubba, RUBBA, and he's been putting out these videos, been going like super viral. And I said, this is perfect creative nonviolent resistance. Everyone wears those outside. It makes giving tickets for non-face masks a little bit more difficult.
That's amazing, though. That's amazing. I actually like that a lot. I really didn't. I noticed you had something on, but I really couldn't tell if it was a mask. Wow.
And if I put my sunglasses on, it looks even better. Like if I back away from the camera and I put the glasses over the line, I mean, there's a guy in the States who has an entire channel dedicated to this, and it looks hilarious and, you know, gets reactions. I don't want to embarrass people who react badly for not wearing a mask, but I'm going to go to the protest to document the protest wearing this, and I suspect the police are going to say something.
That'd be awesome. You gotta film it the right way, because they'll look first, and they'll be, well, is that guy wearing the mask?
I've got 3 GoPros, so I can get I can get the POV. I can get this. What are the dogs doing up there? Okay. Yeah, this was a surprising text that someone, Eric Hunley, EricHunley.com. He texted me and said they're announcing the verdict. I'm like, holy cows, that's fast.
Were you? Well, I'll ask, because I asked uncivil. Or were you surprised at how fast they came back?
Yeah, I'm surprised. I mean, I have no direct experience with criminal jury trials, and much less with jury convictions. I know Robert and everybody says, typically a quick deliberation means a conviction, but there's a part of me that thinks that, and I can't know or not know or disagree with that. I just think a quick deliberation, when it's a complex question of law, might not be the sign of a conviction, because it would be a lot easier to dismiss the charges on short deliberation, as opposed to make everyone appreciate, you have to discuss 3 convictions, 3 different charges, all 3 different elements for the 3 charges. That takes this was less than 24 hours. This was 24-hour deliberation. So it's interesting. And, given the timing of what's been going on politically, politicians getting involved. Anyways, I don't know what to make of it. I just know I've made my prediction based on my own observations. Maybe right, maybe wrong, and it's nothing more than that.
We make predictions, like it's opinions. Opinions can't be wrong, right? It's what we look at the evidence, we look at the law, and we say, well, this is what we think. I'm going into this clearly saying I could be wrong. He could be not guilty on all charges. I'd be surprised, but it is what it is. You know what I'm saying?
I just say, like, for this, when one of the presentations yesterday, and Robert and I talked about it, Nelson, as far as I'm concerned, and it's not because I want to see or read anything, Nelson disappeared, breaking down the excessive force question, reasonable force question for an officer, where I know people are still going to disagree with it, because I still might disagree with it, but he did present a coherent argument for why it was not excessive force in the first place, which then becomes the easiest way to quickly dismiss all 3 charges on their face.
Yes, definitely.
Well, anyways, it's also terrible that a legitimate concern, if not the actual concern, is rioting in the event that conviction doesn't go the way people who are intent on rioting want it to go. This is not how judicial systems can function for any long period of time. It's not how they can function at all. And the fact that this is like the actual primary concern coming out of the judgment and not justice itself is it's not a good sign.
Yeah. I just the couple of things here that I disliked about what's happening now is the political pressure, right? I think well, for a case like this, you got to sequester the jury, because it's just ridiculous. Like, Maxine Waters and all that stuff. I think you kill all that if you have that. And I think the second piece of here is I think the prosecutors, it just was too cumulative. It's you got 20 lawyers, you got this. It almost becomes like almost an equal protection issue. Like, would you do this for any, is this really equal protection? Would you do this to any other criminal defendant? Would you have this many lawyers and put this many resources? Even though the uses resources like it was, at a point, it's like, this is starting to become, unfair, but hey, but justice has a
well, but unfair and politicized, where typically it's the state prosecuting, and Derek Chauvin's attorney is a public defender.
No, he's paid by the police union.
He's paid by paid by the police union, so which is itself sort of a public entity. So you have the
they
government,
have money. They have the money.
You have the government prosecuting and dedicating massive resources. It looks like it comes off as a political prosecution to some extent, whereas in the ordinary run of things, it should just be the same resources dedicated on both sides and not look like it's of special importance to the government to bring in private counsel, and not just one, but multiple, to treat this like the trial of this. I mean, it's the trial of the century, but all for, I'll not say the wrong reasons, but it's...
Well, contrast this to OJ. Remember, OJ was the exact opposite. Two prosecutors and like 12 defense attorneys. But now you got the OJ in reverse. 2 versus 12. So it is what it is.
If you go back to the chat, this chat, regardless of the verdict, how does the U.S. get out of this madness that has gripped the country given the weak? I say this as a Canadian because I was just talking about it with my dad. Like, to see this sort of social cohesion disintegration in real time over the last however many years, and people blame it on Trump. People say that Trump was the cause of, or people are going to say Trump was the result of. One thing, it's just a question of how you see it. They occurred at the same time. How do you need leadership that is going to actually promote harmony and not divisiveness? And it's not coming from either side, really. Whether or not it's coming more from one side than the other, the bad divisiveness, I think it is, but people will call that political bias. But you just need people to tell everyone to tone it down and to come together and not burn the system down if you don't get the results you want, quite literally.
This is for us. Viva and Nate perfectly get perfect on stream with it because they balance each other out. Uncivil. Think we'll see anything go down in Austin. If not guilty.
I wouldn't put it past it. I wouldn't put it past it. I wouldn't put it past it for New York City, for that matter.
Oh no, it's going to go crazy here. You know what I'm saying? If it's not guilty, we're going to have problems. But a good thing I have a lot of my stuff still, so I'd be scared to death. Great stream. Thanks for educating us all. Thank you for being here. Thank you for being here and checking us out. It's at this point, people keep saying that if it's a guilty verdict, riots. If it's a not guilty verdict, riots. I think if you have a guilty verdict, I don't see riots. I see people celebrating in the streets and all that stuff, but I don't see riots. I think you do have, but I think if it's guilty on, let's say, the man 2 and not guilty on the other ones, I think then you have a mixed bag. And it's a shame because it's different. I was watching, I don't know, well, I don't want to spoil it for you guys, but if you guys watch the Winter Soldier, which is called Falcon and Winter Soldier, I've been watching that show, and there is a different experience based on race if you're here in America, and it's different because of where you live, it's different because of who you interact with, and it's different because of where you grow up, right? We all have different experiences, and I think that is something that this country has to still get over, because you got the problem. I think we still have the problem where you have a part of our country who still believes this is 1965, right? Jim Crow law, and it's not that. And then you got the other part of the country who thinks we live in a race utopia, where everybody's seen equal. And it's not that, you know what I'm saying? It's somewhere in the middle. And I think until both sides kind of realize this is not a race utopia, and this is not, 1955, Jim Crow South, then we can start having a conversation about how to get these inequities out. But until we stop talking at each other and start trying to make the solutions together, then we'll always be here. And I think that's the biggest issue that we have now. And I think that's why this issue is coming to the forefront, because, it's they're starting.
Thank you. Please be seated.
Here we go.
You got Larry David in the stream. Awesome.
He's looking at it now. I'm gonna turn my light on.
The pressure that this judge has been under and is still under and will be under after this it's unfathomable.
Here we go.
All rise for the jury.
Are you guys heart pumping out your chest?
I feel
A little bit.
Intellectually and emotionally invested in a way that's
All right, please be seated.
interesting.
Members of the jury, I understand you have a verdict.
Did we find out who the jury foreperson was?
Not yet.
No.
Okay.
We may hear them speak.
Members of the jury, I will now read the verdicts as they will appear in the permanent records of the 4th Judicial District. State of Minnesota, County of Hennepin, District Court, 4th Judicial District. State of Minnesota Plaintiff versus Derek Michael Chauvin, Defendant. Verdict, Count 1. Court File Number 27, CR 20-12646. We, the jury, in the above entitled matter as to Count 1, unintentional second-degree murder while committing a felony, find the defendant guilty. This verdict agreed to this 20th day of April 2021 at 1:44 p.m.
Just like I predicted.
Signed, juror foreperson, juror number 19.
Boom. Guilty.
Well, then the other two are going to go as well.
Caption, verdict, Count 2. We, the jury, in the above entitled matter as to Count 2, third-degree murder, perpetrating an eminently dangerous act, find the defendant guilty. This verdict
Woo!
agreed to this 20th day of April 2021 at 1:45 p.m.
Guilty
Signed by
twice.
Foreperson, juror number 19.
Guilty.
Same caption, verdict, Count 3. We, the jury, in the above entitled matter as to Count 3, second-degree manslaughter, culpable negligence, creating an unreasonable risk, find the defendant guilty.
Damn!
Verdict agreed to this 20th day of April
3 for
2021
3.
at 1:45 p.m. Jury foreperson 019. Members of the jury, I'm now going to ask you individually if these
Gonna
are
poll 'em.
true and correct verdicts.
Poll the jury.
Please
This is
respond
it.
yes or no. Juror number 2, are these your true and
Damn.
correct verdicts?
Yes.
Juror number 9, are these your true and correct verdicts?
Yes.
They're polling the jury.
Juror number 19,
You ask each
are
one of
these
them.
your true and correct verdicts?
Yes.
Juror number 27, are these your true and correct verdicts?
Yes.
Juror number 44, are these your true and correct verdicts?
Yes.
Juror number 52, are these your true and correct verdicts?
Yes.
Juror number 55, are these your true and correct verdicts?
Yes.
Juror number 79, are these your true and correct verdicts?
Yes.
Juror number 85, are these your true and correct verdicts?
Yes.
Juror number 89, are these your true and correct verdicts?
Yes.
Juror number 91, are these your true and correct verdicts?
Yes.
Juror number 92, are these your true and correct verdicts?
Yes.
Are these your verdicts? So say you one, so say you all.
Yes.
Members of the jury, I find that the
Damn.
verdicts as read reflect the will of the jury and will be filed accordingly. I have to thank you on behalf of the people of the state of Minnesota for not only jury service, but heavy-duty jury service. What I'm going to ask you to do now is to follow the deputy back into your usual room, and I will join you in a few minutes to answer questions and to advise you further. So all rise for the jury.
They don't. Essentially, they'll make the defendant. Oh, yeah, they make him stand up. Damn. 3 for 3.
All right, be seated.
It's going to be
Hopefully
an
she's not
interesting.
fine.
Verdicts returned.
See what
We're
the
gonna
impact is gonna be on
have,
police.
Blakely, you may file a written argument as to Blakely factors within 1 week. The
What's a
court will
Blakely
issue
factor,
findings
Nate?
on the Blakely factors,
It's for inherent.
factual
If
findings.
it's if you want to
1 week after
enhance
that.
the penalty.
We'll order a PSI immediately returnable in 4 weeks. And we will also have a briefing on, after you get the PSI, 6 weeks from now, and then 8 weeks from now, we will have sentencing. We'll get you the exact dates in a scheduling order. Is there a motion on behalf of the state?
Move to have the court revoke the defendant's bail and remand him into custody.
Yeah, that's natural thing. Yeah.
Bail is revoked, bond is discharged, and the defendant is remanded to the custody of the Hennepin County
Yeah,
Sheriff.
that's it.
Anything
So
further?
he goes to jail right now, regardless of what
Yeah.
happens.
Thank you.
Yeah. 3 for 3. Yeah, he's got to go to jail now.
Has it ever happened that when they poll the jury, they get something that defies what the
Yes.
written statement was?
Yes. Yes. If one of the jurors, then that's the reason why they do it. Sometimes one of the jurors will say no,
We're adjourned.
and then they have
And
to
then
go back.
what would happen then hypothetically? They go.
You go back. You go
Go
back.
back and do it again.
Yeah.
Okay.
You go back and figure it out.
That was pretty
Well,
quick.
That was.
I mean, that was very quick.
damn.
Not sure what I was expecting, but still.
Oh my God. So we were right on the second degree. We were, but the third degree, as they were interpreting it, I kind of think that's what you got. But it just was the third. If you got the second degree, then the other two are just kind of ancillary claims, right?
Is it possible to like get a feed from outside the courtroom? Because I'd be interested to see, as the verdict was read, how the reaction of the crowd is. Is that possible?
Sure, I'll do that right now.
But
how do you guys feel about the verdict though?
The problem is that politics the politicians ruin everything. They might have come to this very same verdict, and in the absence of Maxine Waters saying what she said yesterday, you don't give fuel to the people who are going to say they were intimidated into this verdict. They were probably intimidated into it, not intimidated into it. They were probably intimidated regardless. It's not a trial that anyone would want to be a jury member on. But when you have politicians saying these things, it compromised, or at least gave the appearance of impropriety to what might have otherwise been the outcome regardless, and certainly gives the grounds for an appeal. But no, anyways, it was the easier decision to make and the easier prediction to make, because first of all, given the law in Minnesota, the felony murder law, I mean, whether or not that turns out to be constitutional or not, it was the easier prediction to make. But there was too much external factors here to taint what would have otherwise might have been the outcome regardless.
Yeah, I want to make it very clear. The reason why I was predicting murder to conviction, it's just because they had to prove an assault. And I understand how people don't, if you didn't want this verdict, you're going to say it's not felony, it's not murder. But think about it, people. For this conviction for murder two, they only had to prove he assaulted the man.
Yeah,
that's such a low bar. It's ridiculously low. It's a bad law. It should be overturned. I don't know if it's constitutional or not, as Viva was saying, but that's as simple as it really got. And when you have something like this, this was my prediction was more about the felony murder rule and how obscene it was, than versus really the facts that were presented. Because I think the facts support it, but the felony murder rule is just ridiculous, and we all know that.
I mean, and there will be a challenge to that. There will be an appeal. There'll be a challenge to the interpretation of felony murder, which Barnes, brings up legitimate points where they make certain distinctions for the underlying crime, excluding certain crimes. Doesn't make sense how the underlying felony to a felony murder could be the assault itself. Whatever, that'll be a question of law. Mm-hmm. Then you got all the external factors of politicians making statements that they know are going to reach the jury because the jury's not sequestered. You got the jury not being sequestered. You got certain statements being made during the trial. There's going to be an appeal, and who knows what happens on appeal, but it's just all of these external factors that taint what might have otherwise been the outcome regardless.
Yeah, I mean, I certainly agree as to the perception. There's, justice must be done and also be seen as being done. There must be a perception and a reality. And so we can split the difference and question both the perception and reality. I think a judgment the other way would also be perceived by other people in the political spectrum as being inherently unjust. As to me personally, I tend to be a little bit more process oriented than results oriented. So yeah. I tend to look for the purity of process rather than the outcome. And for me, there were minor issues, and I think they are minor because it's pretty hard to have a perfect case. It's pretty hard for every decision to be correct. It's pretty hard for everything to be perfect down the line. So were there minor issues? Sure, but there's literally minor errors in all the cases ever. Were these errors really fundamentally different? In my view, no. I think the process was fair. I think the vetting process for the jury was as thorough a voir dire as you could ever hope for. They went through it meticulously. I think the prosecution's case, although a bit cumulative, was compelling. Their witnesses were compelling. I thought the defense's case was underwhelming. Their witnesses were not as believable, not as compelling. And I thought as a pure legal issue, because Minnesota, but as a pure legal issue, yes, I found guilt on murder on the second degree as well. I was convinced beyond a reasonable doubt because of this, and this is an interesting issue because Ben Shapiro and I differ on this as a matter of law and how we interpret what a substantial contributing factor means. So what does that mean legally? Ben Shapiro seems to think it means a dominant factor or the principal factor, and I don't think that's legally right.
No,
I think it's much better as it needs to be significant, but it doesn't need to. So it's a difference between trivial and significant. And what Chauvin did is a significant contributing factor. It's not merely trivial or incidental. It's meaningful. And I think it's hard to conclude, in my personal opinion, that even if the drugs were a factor, even if his natural health was a factor, even if his heart disease, even if his high blood pressures, even if all these things were also contributing factors, even significant contributing factors, I think it's hard to conclude, based on the evidence as presented, that Floyd was not also killed, murdered by Chauvin in terms of the positional asphyxia, in light of all the warnings he was getting from his fellow cops in the crowd and all the rest of it. So I was convinced beyond a reasonable doubt murder in the second degree. I have some fairly technical reasons why I don't think murder in the third degree works. But I think this is a just verdict, and I think it was a just process. So that's what I think about it.
Yeah, I tend to agree. I think this was a slow mode is now on, so 30 seconds. The slow in the chat. I think this was a just verdict. I think it was just based on the law and based on what we know about the law. In New York, it may have been something different. I also think that, again, there are no perfect cases. I think when it comes down to it, it really came down for me, just the ease of the felony murder rule. I just can't overstate that enough. Proving an assault is it's just proving an assault is so much easier than proving manslaughter. No prosecutor or no one who knows anything about American criminal justice is going to say, and that's essentially what they had to prove here. And all the evidence and everything they had to prove an assault. Think about this, if this was a regular assault case with a regular person, would we even really be talking about whether this is an assault or not? And that's what I'm saying. So I think it was cumulative. I think there's some appealable issues, but I think at the end of the day, under Minnesota law, this is the right just verdict. Go ahead, Viva. I'm sorry.
No, I was going to say that the felony murder law in Minnesota is the only thing that can really explain this easily. And some people were saying, well, what happens if you pull somebody over and they have a heart attack because they're scared about being pulled over? Some people were using that false analogy, but it has to require an underlying assault. The issue here is the reasonable doubt that I could see. First of all, the judgment is reasonable given the evidence, no question. I think an acquittal could have been reasonable as well.
Yes,
but the issue here is that it's not an ordinary person; it's a policeman who, by all accounts, was enacting what was to some degree policy. And now the issue became: was it policy after Chauvin, after George Floyd was non-responsive? That's where I've had the issues from day one. And I think the defense did a good job painting the picture of why Chauvin remained on him for the 4 minutes after he was unresponsive. But it's not an ordinary person. It's a policeman who was, to some extent, enforcing policy that he was trained to do, which the bigger risk now is whether or not it's a fair outcome, whether or not the process was fair, and whether or not the process gave the illusion of being untainted by external pressures. I'm not convinced it was. I don't think it was. And what effect is it going to have on policing? Because it is a very, I'm not anti-police, and there's no but. They have a tough job and they need to do certain things. If they feel that they're walking on eggshells, is this going to have a much more negative lasting effect? Or should the policies be revised in all of these police stations? But I've said what I said from the very beginning. It looked terrible. 4 minutes on someone who's non-responsive. You have to have there has to be some compelling reason. Whether or not the mob was sufficiently of a threat, defense did as good as the job that they could. It could have gone either way, and both outcomes would have been equally justifiable. There's nothing fundamentally unjust about the verdict. It's just all of the external stuff that is going to give people the impression that it was the result of pressure and not justice.
This is saying, do they convict? Do they convict on all three? In the case, the greater charge is overturned. No, if they convict on all three, and that's it. Yeah. In other words, they're saying he committed every one of those particular crimes. So
because they all flow from the same act, unless Minnesota law says differently for some reason, then it would be cumulative rather than consecutive. So you would sentence them for every charge separately, but then all the charges get combined. So if the top count, say, is 20 years, and then 10 years and 5 years. The ultimate result of that is 20 years.
Yeah.
So they wouldn't be served in sequence because they all flow from the same event. But yeah, you get sentenced on all of them individually, and then basically the top one is the one that controls.
And it's
That's
up to 40
practical
years. What does this mean for the other 3 officers? That means they're in trouble, because again, they only have to prove an assault. And if they proved it here, then I think you might have the assault down there too, because again, theirs is more of an accomplice to the assault. And
yeah, and the mental state is different, and I think it makes a very substantial difference. Unless something comes to light that will change my mind, I think not guilty across the board for the other 3 officers.
I agree with that. Well, explain the difference between the mental state, because now I know a lot of people are going to be like, "Oh my God, Nate's this, Kurt this," but I agree with Kurt. I think for the other 3 officers, I think they lose based on the mental state. But explain the difference, Kurt. Sorry.
All right, so you have to look at everyone's mental state individually, which I suppose makes inherent sense. So what you believe Chauvin's mental state was does not, of course, read onto anyone else. So you have to consider that separately. So for Chauvin, the question was, did he intend to commit an assault? Obviously, yes. And because if anyone else did what he did, it would be a felony assault, right? If I did it, it would be a felony assault. So his only defense became justification. He can't argue it wasn't a felony assault. It doesn't even make sense to argue that. He has to argue justification instead. All right, so let's turn about the other 3 officers. Their perspective is differently. For them to be an accessory, they have to intend to help someone who they know is committing a crime. And so that's different. Like, so it would be the difference between me helping you as a bank robber versus me holding the door open because I just think you're another customer. You know, it goes to what my knowledge is and what my ability to perceive is. Let's suppose that the bank robbers call a taxi, and let's say that there's a silent alarm, and let's say that the bank robbers come out of the bank just strolling like normal customers, and the taxi takes them away. Is the taxi driver guilty of anything? Of course he isn't, because he has no knowledge from the hypothetical I just gave you to become a getaway driver, right? He doesn't know anything's going on. He's just been called by dispatch. He doesn't have any knowledge that transforms him into an accessory because he doesn't know anything.
Correct.
So the question is, what did the other officers know? And based on large part on their own, like, you should turn him over, you should move him aside, all their warnings and so forth, I don't think that you can get to them intending to help someone in furtherance of a crime. So I don't think that you can get to their intent to become accessories. I don't think their intent works. That's where I think legally it differs.
Yeah. What if Chauvin had shocked him, which the police said as well is within procedures? But generally, I don't know their procedures, but you can't tase someone in handcuffs because people get tased to death. Yeah. So you can't generally with their handcuffs, you can't tase them. And he died of a heart attack. So if you tase somebody who died in a heart attack, it all depends on whether you were justified to tase the person or not. So before he was in handcuffs, if he was doing it, they were justified to tase him or not. So yes, if they tase him and they were not justified, he had a heart attack, that would be felony murder. But
the taser is actually a pretty decent example, because if it's a taser where you have to make contact rather than the prongs coming out, so if it's a contact taser, it might be justified use of force to touch them for some period of time and become unjustified for some longer period of time. So I don't know what the training on this is. Nate would probably have a better idea. But it's like, if it's 2 seconds or 3 seconds, that might be one thing. If it's 3 minutes, that's a whole nother thing. Just because the use of a taser would be justified to some length doesn't imply to all lengths. And for me, whatever the boundary of this justification was, it far exceeded it. So it's not one of those, and this is also why I don't think legally it's what it really should be overly read by police officers as informing what they do on a day-to-day basis, because I don't think this is borderline on justification. I don't think this is like a difference of 10 seconds or 20 seconds that we're trying to splice this really thin. After there was no pulse, I believe he was still on his back for another 3 minutes. Yeah. And it's like, how is that not, whatever boundary there is, that's crossed. So if you want to argue the boundary exists prior to that moment in time, so if you want to argue it exists even earlier than that, I'm not going to fight you necessarily, but I'm going to say it definitely existed at this point, clearly. And after that point, it doesn't make any sense. So I don't think this is nebulous on that ground.
Viva, you made the point about the constitutionality, and John is asking about the constitutional argument. If the Minnesota, because he says if they argue constitution of the Minnesota felony murder, but I don't know what would be the argument?
Yeah.
What would be the constitutional challenge to that? If the police powers of the state, what would it violate?
Challenging what would be I guess the constitutional challenge that I would imagine is that this imposes that it's an incoherent interpretation of the law. Basically, it's not how the law was intended to be interpreted. So they're interpreting it that way, but it couldn't logically be the interpretation, since it basically erases the meaning to any manslaughter resulting in death, because manslaughter basically, which results in death, because now you no longer have any manslaughter, you'll always have felony murder, basically. And so you're giving an interpretation to a law which basically nullifies or invalidates other existing laws, which then should be deemed to be an absurd and untenable interpretation of the law. That's not that it's unconstitutional, that the interpretation being given to it is unreasonable.
Well, see, and that's the issue with our constitutional system, is because this is a state law under the police powers of the state, and if the Supreme Court of Minnesota says this law is legal within their jurisdiction, then I don't really see your federal issue.
Well, no,
unless it's void for vagueness or something.
Well, that's the thing, because we're saying the law is legal, but it's how the law is to be interpreted. They're interpreting it right now to include that the underlying felony itself, which leads to the death, becomes the felony murder, which then, if you on that reading, it invalidates other laws, which therefore means that it has to be the wrong reading. So that's the law itself is valid, yeah, but we're talking about how to interpret that law and apply it to a specific case, where the logical reading of that law, even as drafted, should be that the underlying felony has to be separate and distinct from the act that actually led to the death. Otherwise, you've basically invalidated or rendered moot existing laws, which can therefore not be a valid interpretation.
What you've just explained was called the independent felony rule, and I agree. But it's interesting because and again, this is just my understanding, is that a state law read by the state, Supreme Court, they're the ultimate arbiters of what that state law means, how it's interpreted, and how it's applied. And if they are interpreting and applying it this way, I do think there's a problem. I think it's insane, but I just don't see maybe the federal issue that brings it up. Maybe Kurt, you see something, but I do, and I agree with everything you've said, Grieva. I'm not saying I disagree.
No,
I'm just trying to understand the federal issue that could, because right now, and I hate to even say this, I don't see that anyone would have standing to bring this in a federal court, right? What do you think, Kurt?
Yeah, as to the state Supreme Court, because I couldn't believe this was the rule in the first place, I did a lookup on Westlaw for Supreme Court of Minnesota cases dealing with this issue about whether or not you could use a felony assault as a predicate felony for felony murder. And I found several cases that were directly on point that said, yes, you can. So this is a question that Minnesota Supreme Court has directly tackled on point multiple times. At least 4 or 5 times, and every time they've said it, even in recent vintage. I'm trying to remember when the last time they did it, when it was last century, or 20th century was last time. But they've said if the legislature wants to change this, they can.
Yes.
But this is a rule of law that we have in Minnesota, and we're not going to change it. So I can't imagine the Minnesota Supreme Court is going to reverse that based on anything. The precedent seems clear. And they've considered the question directly, and they said this is a question for the legislature. If they want a different result, they can. And so I don't see that happening. The murder on the third degree is a little bit interesting because there's that, and I could try to find the exact case if you guys want to cover it. But there was a case dealing with whether or not third degree murder could apply if it was specifically targeted against a particular individual.
That was the case that was up on appeal during this case, right?
No, there's an older case that's a little bit closer on point.
Okay.
There's an older case that's closer on point, and I felt like in lieu of that case that third degree murder doesn't work technically. So we'll see how that gets interpreted down the line.
And that's probably have to go up, because I would definitely appeal that too.
Viva, reading Wesley's comment here, if Ashley Babbitt got justice, I would be more okay with this. This is the issue. Everyone has to appreciate the conviction was based on the underlying act being deemed to be excessive force. That's where then once you get to that conclusion, you get to all 3 charges. that was deemed to be excessive force, what Chauvin did. And having watched the video, that was my initial impression, although I saw the defense raise good arguments. Then you get a situation where different state, different law. I don't know what qualifies as excessive force in DC, but I would imagine point blank shooting someone with one shot. If that's not excessive force, and this is, you're dealing with situations that people cannot reconcile, and it's going to cause a great deal of distrust in the system. I'm not jumping to the racial distinctions or the political distinctions. I'm just talking about two different circumstances where, in one case, kneeling on someone's back while they're restrained for 9 minutes is excessive force, and another person effectively executing someone at point blank range, whatever the fear was of that agent who shot, is not excessive force. People are going to stop having faith in the system, and then they're going to look for ways to explain away their loss of faith, and that's a big problem.
Well, I think, well, personally, I think in the Ashley Babbitt situation, it's not comparable in one sense. In one sense, you have people, again, because it's all about context, right? Here, you have a handcuffed suspect, 9 minutes. That's one scenario. There, you have people who are barricaded in, VIPs in the back, and cops with guns pointed at the door telling people, stop, don't come in, don't do it. People, even the witnesses there, said, yeah, we heard the police say, stop, we're not joking, don't do it. They break down the door, right? Break through the door, break through the barricade, and then someone jumps up to get through. At that point, do you let her come through? Do you know what she has? So if I'm saying this, I would have shot Jacob Blake, right? Because I think Jacob Blake was a risk with him with the knife going in, grabbing into the hand, and I would have shot him. I would have shot Ashley Babbitt, right? I would have done that because I don't know what she has. She's in the middle of a riot. She's coming through, and it's not like she doesn't have fair warning. Stop, don't do it. When I tell you to stop, and she chose not to stop, right? She's the one. Now, Ashley Babbitt to me seems more closely to suicide by a cop. If this was just someone jumping through a window and getting shot, that's one thing. But I think the context of the matter, there was, they're screaming, kill a vice president. And we're protecting the exit for the vice president. So, I think nuance is key, I think, with Ashley Babbitt. But I do understand what people mean because
you're talking about the escalation of force based on the threat. And I understand the argument. It's not that I don't understand the argument. And yes, she's in Ashley Babbitt's case, you're in a government building where there are politicians, and it's going to be treated differently. But the question is going to be escalation of force. Why not a taser versus a single shot point blank range into the neck? I mean, the question is going to be escalation of force, and in what circumstances are charges even brought versus convictions? And people are going to have trouble reconciling. There is an argument to be made, but people are going to have trouble reconciling.
Well, I have to respectfully disagree with my friend Viva here on this issue. I don't think it's anything close to an execution in this scenario with Ashley Babbitt. I don't see it. The scenario is so different than anything that's comparable. This isn't similar to the police officer that shot the person in the back as they were running away in South Carolina. This isn't similar to other instances of police abuse. In this situation, you had a large number of people who were shouting things that reflected an intent to harm others, to kidnap others, to commit serious crimes. There's a large number of them, a large force of them. They were barricaded. The police were trying to warn them using other force. And I think that the shot in this situation was a reasonable use of force. I just don't agree with that posture. And
there's two things, not to get semantic on you, Kurt, but it is an execution by definition, which is a putting to death, especially as a legal penalty. So it was a putting to death because that's what it was, as a legal penalty, but as a response.
I would have to disagree, because if you say that, then every shooting by every cop would legally be an execution, and I don't think that makes sense. No.
I was saying, first of all, it's semantically, but when you are killing someone as a threat, I mean, there are different terms to the execution. It is hyperbolic in a sense, but it's also just another meaning of the term, not the legal sense of an execution, which is you have a conviction and you're carrying out a judgment. This was carrying out a judgment just on an instantaneous scale. And I do agree with what they were doing, with what Ashley Babbitt and everyone was doing. You're definitely pushing the envelope as to getting that response. But that doesn't necessarily mean that. Like, what does the police force say for gradient for escalation of force? Why not a taser? And I'm not saying like why not? I don't know what the warnings were. I've seen the video. Chaos.
Police, don't get down. Don't shoot.
Well,
we'll shoot.
Not necessarily, because even the cops behind, there's an argument to be made that nobody heard that because there were cops right behind Ashley who didn't hear it either. So there's arguments, but it's a situation where you are storming a building that has politicians in it. You increase the likelihood of something like that happening. The only question is point blank. Taser could have been another reasonable escalation given the threat. It's not like
those cops. But that's assuming those cops had tasers too. Well, the one that shot Ashley Babbitt was a plainclosed guy. So that's assuming he had a taser.
The question isn't are there other reasonable steps the police could take? Because of course there are. The question is whether or not the step they took was a reasonable step. Not whether there were other reasonable steps.
Whether or not it's a reasonable step depends on whether or not there were more reasonable non-lethal methods that they could have used to attain the exact same objective. So that is what other. First of all, plainclothes officer is another problem in that case, not a good thing. And whatever. Obviously, they're not analogous. The only question is they're going to be perceived as creating two unequal systems, and people are going to look to explain those away politically and racially. And it is the problem when rules are not applied equally, is people look for explanations and they're going to find
the police's role is in this situation, is when we're talking about the Capitol riots, is not only defense of self but defense of others. They're trying to defend themselves against a potentially lethal threat, and they are right to perceive it as a potentially lethal threat because of the numbers and because of what they had already done that day and because of the things they're shouting. Just from raw numbers, they can perceive the threat to themselves and threat to others. So I think that police acts in a self-defense posture, both to themselves and of others in this situation. So again, I have to strongly object to the idea that self-defense qualifies as an execution, whether it's me doing the self-defense or a police officer.
Self-defense has got to be proportionate to the threat. But
yeah, it does have to be proportionate. And for the reasons I said, I think it is proportionate in this situation. I mean, let's just put yours. I mean, okay, just put yourself in this posture.
I understand the argument.
If it's you in this posture, and you have this crowd outside the door, and they're beating down the gates, as it were, both literally and figuratively, and now they're starting to jump through the windows. Would you, as a reasonable person, be able to perceive that as an imminent threat of death or grievous bodily harm? I think you're there.
The castle doctrine. That's essentially what we're talking about. We're talking about.
Go, Nate. If you can bring up Rowan Cloud's comment, if you can see it, it's above the Mike 2017 super chat, 2 above it, where he says, "Viva, storming implies that there weren't people that were waved in by police." We're talking about 2 different things here. The people who were waved in by police, I'm not saying they stormed the Capitol there, but the incident where Ashley Babbitt was, they broke a window and were trying to jump through the broken window. So that I would call that storming. I would call that trying to gain access to a room that was closed. And then the only question is going to be, is a point blank shot the justified response to that perceived threat? And that's where you're going to have people disagreeing. But no, I'm not saying they stormed the Capitol. I saw some of the stuff. They were let in. Others broke stuff down. But at that particular incident, there was a door that was blocked, a window that was broken, and she was trying to jump through the window. I mean, I call that storming, but then we're just...
I'm a huge believer in the Second Amendment. I'm a huge believer of the right of self-defense. I believe it's a moral right to defend oneself against an imminent threat. And I'm just trying to put myself in that posture and looking at the situation, given what I know at the time. All right, what do I know at the time? I know that people have been storming the Capitol. I know there's a horde outside this door that are trying to literally beat down the doors. I know they're trying to break down the windows. I know that they're shouting things that obviously put in mind threats of death and grievous bodily harm, not only of me myself as this cop, but also of the others that are in my charge that I'm trying to protect. Now suddenly I have one of them, presumably to be followed by others, or in that moment, what can I reasonably observe in that moment? I've got this person jumping through the window, even after I've warned them repeatedly. To my mind, and this comes from a position of belief in the Second Amendment, comes from a position of belief in the right of self-defense. It's like I'm putting myself in that posture. Would I reasonably be able to perceive that as a threat of grievous bodily harm? Yes. Could I use other methods? Yes, I could. The question is, am I justified in using lethal force? To me, the answer is clearly yes. And I don't think it's double standards to hold so. I don't think it's an execution to believe in the right of self-defense. And I don't think the right of self-defense changes inherently just because you're a police officer. So, I mean, we don't have to belabor the point because we've been talking about back and forth for a while, but I just have to really strongly, but politely disagree with my friend, who I do consider my friend, even though we disagree.
I never met in person yet. The only one I met is Nate in person right before the world fell apart.
Right before the wars.
My worthy colleague.
Does this apply in Portland? No, Portland's in Oregon. We're talking about Minnesota. So yeah, threatening federal buildings. And again, actually this felony murder rule doesn't apply for defensive property crimes. So if it's a felony defensive property, it doesn't apply. Could Chauvin have claimed to being aroused by the assault?
I think you want to stop reading that comment.
Yeah, this is when
you bring up the chat before we
pass.
Some chats are intended for humor and not necessarily public reading.
Cool. I was going to read it, Mike. Shooting randomly into a crowd is unreasonable. Is reasonable. No, it's not. But shooting toward a threat that's coming through a door, possibly. But again, these things, these things are fluid. Go ahead, Viva.
No, I was gonna say that they're fluid. It's a split second, but it gets very reminiscent to like the cops shooting one protester to send a signal to the rest, which is, I don't know what the rules are on using live fire in a protest. And I think they did an investigation. They came to their conclusions. My questions would be, what were the alternatives? What are the rules about using live fire on protesters? Because that's what they were. They were breaking into a room. Yes. And, whether or not that was a reasonable escalation from a plainclothes officer who had issued a warning, which, may or may not have been heard, given the fact that he could have just as easily hit someone behind her. Just easily been an officer.
Just to be clear, the standard so all we know is, what would a reasonable officer do in the same set of circumstances when presented with the same threat that this officer did? So what they'll do is say, what a reasonable officer facing that same set of circumstances, would they in that same situation, would they had fired, would they had done that? And if it's a yes, then it's justified. If it's a no, then he's not justified. The Women's March during the Kavanaugh hearing won. So people are, now this is against for Kavanaugh, persons were VIPs in the elevator. Yeah, but it's the Kavanaugh thing is a lot different than it's a lot different than
the factual posture is so different.
Yeah.
I mean, the question is almost slightly absurd. To be quite honest, I mean, it's absurd because it's a completely different factual picture. When you're looking at the immediate situation, the immediate surroundings, there might have been more people involved in the Women's March in total. Were those people all banging down the door of the elevator at this? I mean, it's a completely different factual posture.
This one actually, and just we can totally different set of facts. But Anthony brings up the good philosophical question, and it's a tactic that some lawyers have used, in arguments, is if both possibilities are justifiable, necessarily there's a reasonable doubt. So how can verdicts of innocent and guilty both be reasonable and the jury not achieve reasonable doubt? What I mean to say by that is, I can see how the jury reasonably came to the conclusion that there was no reasonable doubt. And I could see how someone who not wanted to, but rather who was inclined to believe there was reasonable doubt could have found it. But it's like the bottom line, especially given the provisions of law, which we all know, like master Minnesota lawyers now, felony murder is almost easier to prove in Minnesota than manslaughter. So
it is. It is. No, that's not that. That is a truth. What you just said was a true statement. But I have two problems with these issues. The verdict cannot be innocent because it's not guilty or not guilty. We're only judging guilt versus not guilt. So that can be reasonable. And reasonable doubt is on the question of guilt, not innocence. We don't prove people innocent. We just prove people guilty. So that's the philosophical problem with this question. It's the reasonable belief on guilt, not innocence.
And let me comment on this question as well. When I say both things are reasonable, what I mean is that when you as a juror are interpreting things, the weight of evidence is a question for each juror, and also the believability of the witness testifying. So when I'm asking questions like this, say, would both not guilty and guilty be reasonable? I'm trying to ask the question, would a reasonable individual be able to perceive the witnesses and the evidence and weigh them in such a manner as a reasonable person could do to come out with both decisions? And I'm like, yes, that's why. So that's why I can simultaneously say, for me, this is proof beyond a reasonable doubt, and also say, but I can see, because I'm answering for myself on terms of how I weight the witnesses and how I weight the evidence. So when I say for me, it's guilt beyond a reasonable doubt, I'm like, this is how I weigh it. But I'm trying to put myself in an objective standpoint. I'm trying to say, could a person weigh the evidence differently or look at the witnesses differently so that they could come out with a not guilty conclusion? Yes, I could see that happening even though I'm not doing it. So that's why I say both are tenable conclusions, but I also say that guilty is the correct verdict from my standpoint, if that makes any sense.
Yeah.
Yeah, it does. Uncivil. You're talking about State v. Load, blah, 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 Minnesota.
1896, that looks right.
Yeah, I don't do the cursory search. Minnesota. Yeah, that's when the third degree. I've seen a lot of those third degree felony murder cases. He's correct. They went way off the rails with third degree. But again, you know, where you do your crime is where you do your time, right? So it's just that.
Well,
let me
gentlemen,
just hold on. I'm just taking care of two more, and then I'm
go for. Sorry.
I gotta cook dinner. 2,300 people, only 850 likes. Come on,
I want to see what you were at now for likes. So let me go ahead and see if that. Did I like this yet? Oh,
I know.
Sacrilege. I didn't do it. You're at 5.
Okay, once you go off, I could go live because I already got it running.
All right, yeah. You already got it running. So listen, guys. I got dinner to cook for children and for a wife because I'm a house mom now. Thank you guys for watching. Thank you guys for joining me, Viva and Uncivil Law. But I'll say this: 2 things. Number one, I think this is important to say. This case, I think, was less about the verdict was less about race and more about police policies. I think race got mixed into it because people saw it in the history of this country. But he wasn't charged with, murdering the guy because he was black. He wasn't charged. He was charged for violating police procedures. And I think people have to understand that too. To say race doesn't play a part in American culture would be naive. But to say race plays a part in all of these cases, I think also is naive. And I think in here, if people are still saying that this Floyd was killed because he was black, I think that's wrong. I think this was I think this was just an excessive use of force, and that's what the jury came back with, right? So understand. I think if you understand it from that perspective, then we're talking law. If you understand it from another perspective, where this is some racial animus, you're understanding from political side. That's why I don't believe that even the newer case, the one with the taser, the mistake in a taser, I think that's an overcharge, right? Because it doesn't, even though race race is apparent, but I don't think it played a role in this case. I don't know if you guys agree with me or not, but I don't think race was a factor in this case.
I think the situations get racially politicized strictly for political reasons. And in the Ahmaud Arbery case, I think race might have played a factor.
Yes,
in
race,
George Floyd, I don't think it did. In Kim Potter, I don't think it did either. It's just that when it's there, the media is going to play it up. Politicians are going to play it up because it's an easy way to garner, get your base excited. And it's an easy way just to drive some political relevance from a tragedy. And it's become a terrible reflex that's become more divisive than unifying at all by only trying to find race in everything. But yeah, no, this is a question of police force from beginning to end, police policy, and so some people saying he got his day in court. Everyone is now going to be able to say that there were other influences that affected this other than justice itself, and that's what happens when the process gets tainted.
With that said, Uncivil Law, you get the last word because we're about to go out.
No, I mean, I've enjoyed the discussion as always. I enjoyed talking to Viva Frei. It's been a while, and I'm glad that we were able to have a conversation again. I hope we can do some more stuff in the near future. I think that this makes a lot of sense in terms of the facts, in terms of the law. Well, the law itself might not make sense, but that's a whole nother set of issues. But I think I think this was a just verdict. Whatever pressures might have been on the jury, I'm as I try to be as detached and reasonable as I can be, and this is the conclusions I've come to, for better or worse. So justice was done as far as I'm concerned. And
just so everybody knows, the streak continues. We're at third. Somebody actually been counting 13-0, baby. 13-0. Well, actually,
you're only 2/3 right. So do you get credit for that?
That's true. Well, I said the top count, but that's true. But they're saying,
I'm going to plug the video that I'm going to drop in right after we end this. Definitely. Project Veritas suing Twitter for defamation. I walk through the lawsuit in the next video.
Good
Boom! Go check it out, guys. My name is Nate the Lawyer, and I'm going to check you next time for Uncivil Law for free. Peace.